Can I give you an example that popped in my head, and you tell
Sure.
me if this is applicable? Okay.
Okay. Yeah.
Let's say you're convicted of possession of a weapon, and the government wants to try to deport you for the firearm. I think it's 237A2E, I believe. They want to get you under the firearm offense. So the statute says a person is guilty of possession of a weapon when they possess a ninja star, B, a knife, C, a gun, D, nunchucks. Right? Does this statute kind of create some of the challenges we're talking about here?
Sure, because what we're seeing here is that if the deportable offense is for conviction of possessing a firearm, the statute that you just described, I don't even know if it mentioned firearms. You mentioned nunchucks.
Gun was the third option, I believe.
Oh, okay. A gun is an option. Okay. But it's only one of, say, 4 or more options there. And so, once again, what was the individual defendant convicted of? And we're not interested in what really happened or what he or she really did. So the challenge here, when you have there's a number of options in this statute that you described. It could be a conviction of a gun, which might qualify as a firearm, but it could also be a conviction of any of these other apparatus. And nunchucks always makes me laugh, but that's definitely not a firearm. So when you have a situation like that, if the divisible statute is where one or more of the options that's articulated in that statute would not constitute categorically the crime or the type of crime, firearm offense, that is being described in the federal deportability ground, let's say. So what we have in that situation is we have to look at the record of conviction. In other words, the record can help narrow it down, but the individual's testimony in immigration proceedings cannot be used to narrow it down.